Hey, it's Chad Brown. Welcome to another episode of the Disability Expert Podcast, where we discuss all things Social Security disability with my trusted senior associate, Aaron Dalton.
Good to be back.
One of the things I think it's important for people to understand to overcome the Social Security disability process is they need to understand that there is a process. There's a decision-making process, the 5-step sequential evaluation process, and so I thought what we do today was actually go through an overview of the 5-step sequential evaluation process. A lot of people ask, well, how does Social Security determine if I'm disabled? How do they actually make a decision? And the short answer is they use the 5-step SEP. Let's just dive into it. Step one is the question of substantial gainful activity, which is basically a working question. So just go through real briefly and explain what's happening there at step one.
At step one, the judge is basically looking to see, is this person making too much money to receive disability? So the judge is not even looking at the medical impairments, the symptoms, strictly a money question at step one.
Right. So I think the number for 2026 is like $1,690 a month.
$1,690 a month.
Now, let's just break that down without getting deep into it. There's really sort of two different scenarios by and large that present themselves at step one. You have what we consider just a classic, typical W-2 employee.
Right.
You work for someone else. You get your W-2 at the end of the year. And then you have people who are self-employed in varying capacities. So let's talk just briefly about the W-2 employee. So the number is 1690 for 2026. What actually are they using to determine whether you are above or under the 1690 number?
For a W-2 employee, and a lot of clients get mixed up on this, they're not looking at the take-home pay. They are looking at the pre-tax income that you're making for that employer.
Yeah, so they're going to look at basically your gross income. How much do you make before you pay taxes, before you pay FICA and Social Security and all the wonderful things the government takes from your check every month. But it's the gross number. So if you're someone who makes $36,000 a year and you make $3,000 a month, that would be what your number is. It's $3,000. With the only caveat being, there can be reductions for what are called impairment-related work expenses.
Yes.
Real briefly, what's that?
Essentially, if you have something that you're paying for that's health-related that allows you to do that job, Social Security can deduct that from the amount from the $3,000 that they're looking at. So, for example, sometimes biologic medications like Humira are very expensive out of pocket, and you can actually deduct that from the $3,000, and Social Security may take that into account.
Yeah, and so the logic there is basically the only reason I'm able to earn the amount that I earn is because of the impairment-related work expenses that I incur. It's unfair to penalize me for paying those out-of-pocket expenses and being over the number, because if I didn't have those expenses, I couldn't work at all, and I would reasonably be under the number. So other than that, really no exceptions there. They're looking at what your earnings are. Typically, they do an averaging, though. When you're looking at a range of period of time, they're going to do an average. They're not just going to go and look at 1 month where you were over SGA. Is that generally right?
Right. Generally, they'll do an average. Sometimes they might do an unsuccessful work attempt or something that I believe we've talked about in other episodes.
Yeah. So the fact that you have worked for periods of time once you've been out of work, as you're trying to, say you try to return to work for 4 months and you work over SGA, so you made $3,000 a month, just use that even number, but that work attempt failed, then they would exclude those. As long as you jump through the hoops and meet the parameters, they're gonna remove that. But generally, step one is a working question. It's going to answer the question of whether you have substantial gainful activity. And then with self-employed people, I think the easiest thing people can do is we shot a 2-part episode on gig economy jobs.
Right.
But the first half of that gig economy job episode, or part one of it, really dives deep into the self-employment rules. There's 3 different tests that they go through to determine if you have self-employment income that would equate to substantial gainful activity. I think the big takeaway for people there is it's not the same number.
Right.
That number factors into some of the consideration, but the reality is is if you are a self-employed person, you need someone, probably an attorney, who understands the rules to help navigate
For sure.
to make sure that you're not over that. There's a tremendous amount of misinformation about that with people who are attempting to work. I know in the leads we screen every month, we have a lot of people who are working and they're like, "Oh, I just do Uber, I just do DoorDash," and we're like, "No, no, 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 don't do that. We have to do the correct calculations." But beyond the scope of our talk today, but there's a two-part episode on self-employment income, gig economy jobs. Go check that out, and that'll give you everything you need to know about that. So if they determine that you're over SGA at step one, what happens?
Nothing else happens. Your case is gone.
Right.
There at step one, denied.
So one of the ways, if you sort of think about this sequential evaluation process, is maybe I don't know. I don't know if it's better to think of about it going downhill or uphill. I don't know which way it is, but they're sort of off ramps. And one of the off ramps is if you're over SGA, you're gonna lose your case. Um, and there's really nothing else you can do, because at the end of the day, Social Security disability process is a program for people who can't work. And if you work and are able to earn above a certain amount, then you're just not eligible for the program. All right. But let's say we're under. Let's say we're under SGA. Let's say we had a client who's making no income, which, by the way, is the best way from an income standpoint to go on disability. What's going to happen at step two? What are they going to evaluate there?
At step two, we actually now get to look at the medical conditions, and sort of the catchphrase that we're looking for are medically determinable severe impairments.
Okay.
It's a little bit of a term of art, the severity there. Essentially, what Social Security is looking for is a health condition that has lasted 12 months, is expected to last 12 months, or is expected to result in death. And they're looking to see, does this impairment cause some kind of work-related function? So step two is supposed to be a fairly low bar to clear.
Yeah, and there's two sort of factors there. It's medically determinable severe impairment. And so medically determinable, this is where I think people sometimes fail to understand the significance of medical records. Your impairment has to be medically determined, not client determined.
Yes, it can't be, well, I Googled it and I'm pretty sure this is what I have.
I mean, I'm a huge fan of AI. That's probably another whole episode. We did an episode. That's right. We had Nick Coleman on, who runs LexMed AI. But I'm a huge fan of AI, and while I firmly believe that it might be able to give you a diagnosis, the Social Security Administration at last check does not count Claude as an acceptable medical source. So you're going to have either documents, or you're going to have imaging or records that are going to support that this impairment is it's a medically determined impairment. And then severity, like you said, it's a relatively low bar. Is this impairment such that it's going to cause some level of work-related dysfunction or limitation? It was funny. I was a prosecutor a long time ago, and they used to talk about grand juries, and we say you could get a ham sandwich through grand jury. Just it's a very, very low standard, right? Doesn't mean we don't lose cases at step two. The biggest reason, though, historically, I see cases losing at step two is the durational requirement, not necessarily the medical determination or severity. So talk just a little bit about that. Like, what would be some examples where someone should be concerned about the 12-month durational requirement for the medically determinable impairment?
I think the easiest example for this is somebody who maybe had a traumatic hospitalization, and they were in the hospital for 3 or 4 weeks, and those records look very, very bad. But then after the hospitalization, thankfully everything got better, got stabilized on medicine, didn't require very much medical follow-up. That starts to look like a case where this person was in really bad shape for a month or two, but there's not that 12-month durational period for us to win a case on.
Yeah, and you see this with traumatic car accidents, stroke. Stroke's a pretty common one, where people will initially have a very significant level of impairment. It's severe, truly severe, but they recover. Thanks to modern medicine. A lot of the impairments and sort of traumatic related incidents that maybe historically might have been disabling now have a resolution within 12 months. Then you get into people who have sort of traumatic incidents and you go beyond 12 months, but they're able to return to work. So the other side of that is, yes, if you don't meet the durational requirement of 12 months, you're going to lose at step 2. But if you exceed the durational requirement of 12 months, let's say you go back to work at 14 months, that does mean you can be paid for that period of time
Yes.
in a closed period.
We can do a closed period.
Yeah. So I think sometimes people think, well, I got better, but they don't understand really only matters is what was your level of improvement before the 12 months
Right.
And if it exceeds 12 months, then there's opportunity there for a possible closed period. So let's go through. We're not working. We have an impairment that's going to exceed 12 months. It's medically determined. It's a medically determined impairment, and it's severe. What's going to happen at step 3?
Step 3 is interesting because you cannot lose at step 3. You can only win at step 3. So the worst that can happen is you don't meet step 3 and they just move on. So it's a little bit different from the other steps. And basically what we're looking for at step 3 are the listed impairments. So Congress has gone through and sorted the different types of impairments that might be so bad that we're just going to go ahead and assume that you're unable to work if you meet these very strict criteria outlined in the listings.
So generally, what I usually do is say there's these categories of impairments. A simple way to think about this is sort of high school biology. There's certain body systems, cardiovascular, neurological, musculoskeletal, hearing, vision, just sort of break your body up into sort of major organ systems. It's not exactly that clean within the listings, but just in terms of understanding it. And for example, let's just use a heart condition. So let's say you have congestive heart failure, you have very low ejection fraction, and there's going to be a specific set of rules that look at specific heart impairments. And you're going to have to, though, jump through some very technical hoops. I think the listings at one level are the easiest way to get on disability because if you check the boxes, you win.
Right.
There's zero sort of discretion for meeting listings. There's equaling listings. We'll get back to that in just a second because I think people need to understand the difference. But another level, the listings in some respects may be the most difficult way to get on disability because the requirements are very, very specific and typically are very significant in terms of impact. So I think one of the big takeaways here is while we could look at medical evidence as your attorney and argue that a listing is met, typically what you want is your doctor to say that they believe you meet the listing. And unfortunately, now we're into engaging with doctors. There's another whole episode on that where we talk about engaging with your doctors. This is important though, because your doctor will almost certainly have a working understanding of the components of a listing.
Right.
Your doctor is going to understand a stress test. They're going to understand ejection fraction. They're going to understand the lab reports requirements. Some of them have lab requirements. They're going to understand medically what is needed. What they're almost universally never going to understand is what the listing actually requires.
Right.
Yeah. So I think when people have listing level or potentially listing level impairments, historically what we're going to do is we're going to go to their treating doctor. Often it's a specialist because usually the listings are looking at the level of severity that the client is probably engaging a specialist. So let's just stay with the cardiology example. You're going to go to their treating cardiologist and say, hey, we think they meet the listing. What we'd like you to do is review the listing. So you actually send them a copy of it, or their nurse manager usually is who's actually getting it, and say, we think they meet this. Ideally, you're sending it to them saying, we think they meet this because on, record, this date, this page, there's this finding, this record, this date, there's this finding. We're reading that saying we think the listing is met. Do you agree with that? And if so, would you write a letter that states that? The difficulty is getting doctors to do it.
Right.
Or failing to understand that while your doctor very well has the knowledge to say if you do or do not meet the listing, they don't have usually any idea either what the listings are or what the requirements are. That's sort of meeting listing. And meeting a listing means you technically meet the requirement. There is this concept of equaling a listing. Can you just talk briefly about what that is?
Sure. So with meeting, they're really just looking at the one problem that you have. That's probably the worst thing that you filed for. Equaling can be either you're so close to meeting that definition of the listing, but maybe you fall just a little bit short. They can kind of wave you through and say, close enough. Or maybe you have a second level impairment that's still pretty bad. And the judge can look and say, okay, well, you don't quite meet the listing for the first impairment, but you're pretty close anyway. And you have the second thing going on. I think that puts you close enough. But really with equaling, it's supposed to come from a medical expert. So sometimes at the hearing level, usually is when we see it. The judge may have a doctor come in, look at all of the records combined and say, in that doctor's opinion, do they think that you equal any of the listings?
Yeah, and I think practically one of the differences is it's not that your treating cardiologist could not say you equaled the listing, but by and large, they don't have a nuanced understanding enough of the Social Security disability process that either they can do it or they're comfortable doing it. So I think from a very practical standpoint, if your medically determinable severe impairment is such that you are potentially meeting that listing, your treating doctor could be very helpful for that. As long as you give them the listing and walk them through it and help them understand what you want and sort of hold their hand a little bit. But equaling a listing is something that historically you primarily see in the context of a medical expert at the hearing. And surprisingly, they say that more than you think.
Yeah.
Yeah. I mean, so sometimes the medical expert shows up and you're like, man, this is either going to be really, really good or it's going to go really, really bad.
And we have no idea before the hearing what
Yes.
they're going to say.
Yeah, they don't let us oppose them. They don't let us do the things you would do in typical litigation because it's non-adversarial. That's right. The whole process is non-adversarial. So you could win your case at step 3, but you can't lose your case at step 3. If you don't meet a listing, then you move to step 4. What's going on there?
Before we get to step 4, there's this residual functional capacity that we need to talk about, the RFC. We have an episode.
Yeah.
Watch the RFC episode.
Yeah.
But essentially the judge is assessing after step 3, but before step 4, what the judge thinks our client can still do. Once the judge has determined that, then we get to step 4 and the judge is asking, well, does that residual functional capacity allow this person to go back to their past work, either as they actually performed it or as it's generally performed in the national economy? And past work is past 5 years typically.
Right. So RFC is and let me be clear too, the RFC is the maximum amount that a person could do on a sustained basis for a 12-month period. This is not a question of what they could do on a good day or a bad day. This is where I think in some respects, for example, a workers' comp independent medical exam, which is sort of looking at your maximum ability, but really at the end of the day, all it's really testing is what you could do on that given day.
Right. For the 2 or 3 hours you were there.
Right. With really no thought about how it impacts you tomorrow, whether you were having a good day, whether you were having a bad day. The RFC is designed to say, what's the maximum exertional capacity this person has? So they look at the exertional, sit, stand, walk, push, pull, carry, lift, and then they look at a range of non-exertional. Like you said, we did a full episode on RFC. We actually went through and did, I think this 2-part episode too, I think, where we go through and look at some examples. So, but understand when you get to step 4, the judge is taking this created RFC and applying it to your past relevant work, jobs you've done the past 5 years. So what are the possible outcomes that can come from that?
So at step 4, the judge could say that even with all of your medical conditions, your RFC is such that you could go and do that job as it's generally done. Or the judge could say, you know what, you've got so much going on, you're not going back to your past relevant work.
Right. So if you're found to be able to return to your past relevant work, we're on another off-ramp and your case is over. If they find you cannot go back to your past relevant work, do you win your case then?
Got to go to step 5.
Yeah. So the other thing too, I think, is understanding is that at step 4, the burden is on you. I mean, technically the burden's on you through 1 through 4, but the burden is on you to establish that you cannot return to your past relevant work. I think in terms of past relevant work, at the step 4 process, just a couple of high level points to understand. One, it's very important that you get your work history report done correctly in your application, because very often people sort of gloss over that. And then you end up in a hearing and you're like, that's not really what I did. I did this. I had to lift this much. I had to do this amount of standing or walking or problem solving or whatever it is, right? And that wasn't in the file correctly. And so now all of a sudden there's not only a debate about whether you can do your past relevant work, the debate is really about what your past relevant work actually consisted of. And the other thing is understanding, you've got to look at exertional and non-exertional requirements of that job, because they're going to be compared to your RFC. And what you're trying to do is look at core components of that work, exertional and non-exertional requirements, and be able to show that because of the nature of the impairments that you have limitations such that you're unable to perform those. And at a very high level, that's all you're doing. You're saying the job requires X, Y, and Z. I can only do X and Y. I can no longer do Z because I can't meet all of the requirements. I'm unable to do the work.
Yes.
Right. So then we get to step 5. So if you survive step 4, you've proven that you can't do your past relevant work. What's going to go in there at step 5?
So step 5 is the other work question. And the good thing about step 5 is the burden here actually shifts to Social Security. And now it's their job to demonstrate that there's a significant number of jobs in the national economy that you can still do on a full-time sustained basis with your RFC.
Right. And I think there's really, it's sort of in practice, it's a 2-part process. First, they're going to look at your age, education, and work experience in conjunction with your RFC, and they're going to use the grid rules. Another 2-part episode we did on the grid rules. We forecasted for weeks, and then we did a 2-part episode on the grid rules where we not only explain how they work, we go through real examples. The important thing there is, once again, if the grid rules determine that you're disabled, the judge really doesn't have the latitude to deny you. So even though the burden is now shifted to the Social Security Administration to say that there are substantial number of jobs in the national economy that you can do, initially your case is likely going to be run through the grid rules. And those grid rules for certain people, those over 55, those over 50, those with limited job skills, low education, all the things that made it hard to have a good job in the economy when you're working, are going to work in your favor. If the grid rules do not find you to be disabled, then there's actually an additional test that's done where the judge has to look, well, are there other jobs you can do in the national economy? That's typically when the vocational expert comes in. So sort of just briefly, what's the vocational expert's role in, how does the judge and the vocational expert engage in a hearing to help resolve issues at step 5?
So the vocational expert, big picture, is there to tell the judge, with the RFC limitations, can this person either go back to the past work, or is there other work this person could do with the RFC? So the vocational expert there is not there to tell us what your RFC is. A lot of people get mixed up there. That's the judge's job. The vocational expert is just there to tell us, with this RFC, are there jobs available, and in what numbers?
Right. The vocational expert, I mean, technically they participate at step 4 because a lot of times they're classifying your past relevant work.
Right.
But generally what the judge is going to do is they're going to say, assume a hypothetical individual, and it presumably should look like you.
Right.
They can only sit this much, stand this much, walk this much, carry this much, lift this much, and they have these additional limitations, whatever they are. Assuming that person existed, what jobs, if any, could they do? And the vocational experts are either going to say no jobs, or they're going to testify to jobs and numbers, and that's another whole testimony. But and that at that point, once again, you have sort of 2 options. The judge could say, I believe there's work you can return to, or in a favorable decision, they'll say, hey, we don't believe you can, there's substantial number of jobs in the national economy you can do, therefore you're disabled.
Right.
Very good. That's it.
All right.
5 steps. So understand when you come into the disability process, this is not a subjective, so to speak, process. It feels subjective at times. It can feel arbitrary at times, candidly. But the reality is there's a very strict set of standards, the 5-step sequential evaluation process. It's used at the DDS levels. It's used by the judge. Even in the federal court space, typically the review in and of itself is engaging different parts of that 5-step process. The judge should have found you met a listing, but he said that you didn't. The judge determined that your past relevant work was of a certain nature, but it wasn't. The judge's hypothetical failed to consider certain things that were substantially supported in the record for your RFC. The point is that at every step of the process, this 5-step sequential evaluation process is what is guiding the decision maker or the court to make a determination if you're disabled or not. And so at the end of the day, what determines whether you're disabled or not for the Social Security case is whether you're able to successfully navigate the 5-step sequential evaluation process. So that's it. I hope that's helpful. It's one of these things where you need to understand that process because it's going to impact how you build every step of your case. Decisions about work, trying to get medical evidence to support the impairment, whether you're able to get your doctor to engage you successfully or not, understanding how RFC is impacting your other work, understanding the grid rules, that this all sort of works together because that's how they're going to make the decision. So that is all we have. There are a bunch of episodes where we go through a lot of the different component parts of the 5-step sequential evaluation process. If you have questions about any of those steps, I believe at this point, other than the listings, we've shot episodes on almost every issue that's related inside the 5-step process. Watch those. Thank you for watching. Till next time, take care. Oh, and subscribe. Thanks.